to tell the court about your request for a show cause order for contempt as to Mr. Schmalfeld's not answering interrogatory number 8?
Well, I received an email from an anonymous email account reporting to me from Mr. Schmalfeld that gave what I viewed as an implausible answer. And that's the only answer I have received yet. So first of all, I don't have any actual indication from Mr. Schmalfeld that he's responded. And secondly, he has responded that he is the editor of Breitbart Advance and has no idea his position. So if I'm to believe the email was sent to me anonymously.
All right, so what, are you indicating, Mr. Hogue, that Mr. Schmalfeld did not file or tender to you an answer to interrogatory number 8 in the form required by the Maryland rules?
Yes, sir.
Okay. For the record, interrogatory number 8, which the court ordered Mr. Schmalfeld to answer, reads as follows: identify any person, and the person is defined in the instructions, who has exercised either editorial or managerial control over you in connection with your work as an editor or writer for the website Breitbart Unmasked, describing the nature of any such person's supervisory role. Mr. Schmalfeld's initial response to that was that he objected to that as relevant. The court ordered Mr. Schmalfeld to answer that. So, Mr. Schmalfeld, sir, you've heard Mr. Hogue's contention that you did not answer to interrogatory number 8. What do you have to say?
I say, Your Honor, with all due respect, Mr. Hogue is lying to you. On his blog on January 16th, 2017, he admitted that I answered the interrogatory. And I can read that portion to you right now, Your Honor. It's from a post called the Team... I'm sorry?
Hold on, Mr. Schmalfeld. Before you do that, did you answer the interrogatory?
Yes, I did.
And in what manner did you answer the interrogatory?
Here is my official answer. I answered him via email, which he was happy to accept up until very recently. And my answer to the interrogatory, digging through my paperwork here, was it's answered to the very best I can answer it. And it is, I'm looking again for it here, because my papers dropped off the ledge.
Since you're hearing Mr. Schmalfeld via video conference today, you're not able to obviously hand me a document. Is there a document in the court file that you're aware of that I can look at that can show me what your answer consisted of?
Well, since the interrogatories were not subject to be sent to the court's attention, there is an exhibit, I believe, in Mr. Hogue's, and again, excuse me for some word-finding difficulty from time to time. There is an exhibit in Mr. Hogue's, what I was served by the Clinton County Sheriff's Office, that includes an email I sent to him that says, here's my answer. And he says at the end of the blog post, so now I have Bill Schmalfeld's answer to the interrogatory. It was made under penalty of perjury. We'll see if anyone believes him. Now, if Your Honor, if I could enter into the record, I can share with you what that answer was.
Go ahead.
All right, sir. Answer number 8. Nobody. No one had any editorial or managerial supervision in connection with my work as an editor or writer for the website Breitbart Unmasked. I never knew the name of the person who operated the Breitbart Unmasked website. I still do not know what that person's name is. No one edits or supervises my writing. I submitted articles just like you do, again addressing Mr. Hogue, when you post an article on your own WordPress blog. It always shows up as submitted. Again, no one is exercising any editorial supervision. It is a voluntary position. It's something I do because I enjoy it. And the term editor is kind of an honorific I've given myself.
And when did you send this email to Mr. Hood?
I have that date right here, Your Honor. It was the, I believe, 16th of January. It was within a couple days of your order that I answer the interrogatory.
My order is dated January 4th. It was entered in the record by the clerk on January 5th.
All righty.
You sent it 11 days later?
I sent it with, let's see here, I have it right here. I emailed my response to the interrogatory on January 12th. And then on January 16th, the plaintiff wrote a blog post in which he complained about the fact that he had received my reply via email. But again, he says, I now have Bill Schmalfeld's answer to the interrogatory. So, Your Honor, I submit that when he tells you he has not received an answer to the interrogatory, he is bald-faced lying to this court.
Mr. Hood, you want to respond?
Your Honor, things that get written in a blog post before they are processed completely are not matters that you should rely on completely reliable. I did receive the email from someone. I do not know who sent me that email. It was sent from an anonymized account. A long string of characters here at guerrillamail.com. So I didn't know, and I really didn't know at the time I wrote that blog post, that it was in fact from Mr. Smallwood.
Well, as I said at some other point in this proceeding, the court notwithstanding the fact that none of the parties in this case are represented by attorneys, the court expects all parties to comply with the Maryland rules of procedure. And I would note that it's, I think, common knowledge, I would say, when we're to review the pleadings just in this record alone, that one or more of the parties to this case have been parties to any number of other